So, as Milton mentioned, mine are the first materials in the handout. And we're talking rights and duties of condominium directors, and the first issue is fiduciary duty. And if you forget all the rest of what we talk about today, if you turn to the last page of my materials, page 7, this is a section out of the law which deals with fiduciary duty and the responsibilities of directors. And it's a reference to the nonprofit law. And it says what a director is supposed to do. They're supposed to act in good faith with the care an ordinary person would exercise in a manner they reasonably believe to be in the best interest of the corporation. And then in doing that, subsection B, they're entitled to rely on certain things. So if you forget what, just remember section 414D 149, because it's like a little roadmap of things you should know as a director. What should you be trying to do? And you should probably notice subsection C of that section. A director is not acting in good faith if the director has knowledge concerning the matter in question that makes reliance by the director unwarranted. So, for example, if you're relying on your brother-in-law to undertake some very difficult renovation at the project and he knows nothing, you can't turn around and say, well, I should be protected because I relied on my brother-in-law. You have to be able to reasonably rely. So to expand a little bit on that, the fiduciary duty is imposed on you as a director because you're acting for other people. And part of what you're supposed to be, I've summarized really what is said in 414D 149. Diligence, you're supposed to, your fiduciary duty includes duty of diligence, act as a reasonably prudent person, good faith. This is the empty head, pure heart. You may not know what you're doing, but as long as you're doing your best with no hidden agenda, that's good faith. Loyalty, you're not supposed to be using your position on the board to make things better for yourself, particularly if it's at the expense of your fellow owners. And then obedience. If the President of the United States doesn't get to do whatever he wants, neither do you. So you have to read the documents. You have to know what your authority is. It is often very broad, that's true, but it isn't unlimited. So be aware of those 4 basic principles: diligence, good faith, loyalty, and obedience. There's also something called the business judgment rule, which you will often hear referred to, and I've never quite worked out whether that's supposed to be the same as your fiduciary duty or something different. But it's a similar analysis, and really I think the focus in the business judgment rule is more when you are doing business-like things, entering into contracts and that sort of thing. Fiduciary duty seems to be more something you would be subject to when you're acting for your owners in dealing with the owners and dealing with non-business activities. But the business judgment rule is very similar, how an ordinary prudent person would act in the same circumstances. It's supposed to be if you're behaving reasonably and in good faith. There's Hawaii case law on that, which says that's what the business judgment rule means, that the director or officer acted reasonably and in good faith. And I've summarized bottom of page 1, top of page 2, what that would involve, which is keep informed, attend and participate in meetings. You shouldn't sign up for the board if you're going to stay home and watch TV. Make sure your absences and objections, if you don't think the board's doing what it should, which can happen, you should try and make sure that that's recorded in the minutes. Act in the best interests of all owners and avoid conflicts, not exceed your authority, act in a timely manner. So what it really comes down to is like mathematics. You get more credit for doing what you're supposed to do, even if you get the wrong answer, because that's what the courts will look at. Did you follow these steps? Did you just shoot from the hip, or did you do a careful, systematic analysis of what you're supposed to be doing? And so that's the next section, the importance of procedural requirements. So you don't necessarily just want to make a good decision, you want to be able to prove to people that you did make a good decision by laying out the groundwork to show that you did what you should have done. And so that's one of the things you should keep in mind, because you're almost bound to screw up if you're on the board at some time. But again, just like mathematics, you get the wrong answer, but you did it in the right way, you will get credit for the procedure, even if you get the wrong answer. So records, I mentioned here, records, that's usually quite important. Make sure if you're voting on something as a board member that you include your vote. If you're objecting, certainly you should do that. You should try and record. If you're hiring a contractor, you might want to put in your minutes that you reviewed proposals from X, Y, and Z contractors. This shows that you did something carefully and thoroughly. If you're not at a board meeting and you look at the minutes, you should probably make sure that's not something that it should be reflected in the minutes. And then don't say stupid things in public. Don't say, we don't want any of these people in. That's what happened to Donald Trump. He said all those stupid things before the campaign. Now he's doing things he probably could do anyway, but the judge is saying, oh no, because you said all those stupid things before, I'm going to question your motives in this. And that's what can happen to you. If you say we don't like somebody and then you end up legitimately taking action against them, that will come back to haunt you, because that's what they will look at. Employees, you should be trying to keep some eye on employees, although your managing agent should do a lot of that for you. But ultimately, as a board member, you are responsible for what they do. So if they're going off the rails, you should try and make sure that you bring them back, or if you have to, find someone else to do their job. Contracts. The most common question we get as attorneys is, how do we get out of this contract we signed? Because they don't want to spend the money to at least have us point out some of the problems. And then they sign up, and then they find out there's a 500-year rollover clause or something like that. They can never escape. And then they say, how do we get out of this? So it might be better if you're on the board. And again, it's a form of insurance, not just attorneys, architects, engineers. If you consult them, it's a form of insurance. You can say, I didn't know what the hell I was doing, but I did ask this architect, this engineer, and I took their advice. That is a form of insurance for you as board members, because if you try and make decisions where you have no expertise, no knowledge, you're not going to meet that requirement that we talked about in Section 149. Keep records of owner problems and violations. Sometimes we see where the owner does stuff for 6 months, nobody writes it down. Finally, the board gets fed up. They have one citation and they say, we want you to take legal action against this owner. And we say, well, what have they done? And they say, well, here's the citation. We say one citation, say, oh no, this has been going on for 6 months. We say, well, where are the other citations? And there aren't any. So it's important to keep those kind of records. Page 3, you'll see some others. Financial controls, sometimes that can be a problem. I've seen that happen. Hire licensed contractors. Usually when you're a board member and you try and cheap it out, there's really 2 rules. Do a good job, and number 2 is protect yourself from unnecessary liability. The problem you have when you cheap it out and get an unlicensed contractor is if they screw up, it's going to be worse for you. And what you did is you saved everybody money at the expense of raising your own personal liability. So what's the point? Why would you do that? Consult experts, we talked about that. Keep written records of important actions not covered in the minutes. And then Jane is going to cover this, but I just have a little bit about owners. Owners have to think in similar terms. If they're going to complain about what the board did and they complain verbally for 6 months and then suddenly fly off the handle, they don't have any record that they even told the board what they were concerned about. Second thing you should think about, due process. This is fundamental in the US, maybe not everywhere, but it's supposed to be things like the punishment should fit the crime, so don't fine somebody $500 for leaving their slippers outside the door and expect the judge to agree with you. And then before someone's penalized, they're supposed to give notice and an opportunity to be heard, even if it doesn't say that in your documents. This due process principle is hovering above you at all times, and that's what judges like to see. That if you're going to be mean to someone, you did it in a careful, fair, and systematic manner. And it's the same people in similar circumstances. The president can't park in the guest parking and then say, well, none of the other owners can do this. You have to treat similarly situated people similarly, unless you can show legal or factual reasons why you shouldn't. So I just put at the bottom of page 3, when you're looking at this due process, do you have the power to act? Check the Deccan bylaws. They may not say you can do what you want to do. Was the procedure for your rule reasonable? Is the content of the rule reasonable? Is the rule applied reasonably? And Milton's going to go into this in detail, so just a brief summary of that. Let's see. Penalties for rule violations. I think that maybe will be something Milton's covering, but you should be very clear on what the penalty is, and you should make sure that you communicate that to the person you're going to penalize, but I think Milton will cover that. Collections. This is something you have to be careful on. You want to be making sure that you have a nice, well-communicated procedure to the owners, because otherwise they will probably complain that they weren't given the right notice. You should remember the law says when you increase the maintenance fees, you have to give 30 days notice. But again, Milton will cover, I think, some of this. Self-help. A lot of boards think, well, why don't we just take that old refrigerator out of there, off their lanai, and throw it in the garbage and that will be done. It's not a good thing to exercise self-help unless it's very clear what you're doing, because that is basically what the court system is there to prevent. Instead of people taking the law into their own hands, which is essentially what self-help is, the court system is there to have an adjudication of whether that action is justified. So if you are going to exercise self-help, just put a little asterisk saying, I should be very careful about doing this, because it can come back to bite you. You throw away the old refrigerator and the owner says, that was a $300 refrigerator, give me the $300. Bottom of page 4, public relations. This is something that when I was the state condo specialist, it was always astounding to me. So you are a politician when you're on the board. It isn't all just the law. It is politics. So you have to have some kind of bedside manner. You can't just say, legally, you probably can tell people, well, we don't have to listen to you. This is a board responsibility. We don't care what you think, which is probably true and may actually be actionable. I mean, you don't necessarily have to care what they think, because if it's your job, you get to make the decision. But if you tell people that, it just upsets them. So it's not usually a good idea to tell people the truth in this area, that by electing us, you gave up 95% of the control of your life, because they don't want to hear that. So you should be thinking in terms of your bedside manner as a director, because that can backfire. People will get so annoyed, they will run against you. They will try and remove you. So remember, you're not just a legal person, you are a politician. And of course, the same is true of owners, which, Jane, if you go in and yell and scream at board members, you're probably not going to get things that you might if you went in a little more carefully and politely. And it may be my English upbringing, but I find it extremely offensive when board members or owners are offensive to each other. It's just so unnecessary. So I think that's something to keep in mind, because that's what sets people off. They will be gunning for you because you cut them down at an annual meeting 5 years ago and they feel it was unfair. And they'll be looking for things, violations to use against you. So keep in mind, being on the board, you are a politician. Communications. Let people know what you're doing. I remember years ago when I was a condo specialist, some guy on the top floor, he kept getting leaks in his unit. The board was working on fixing the roof. They were doing all this stuff. They had a contractor ready to go. And finally, there was a big rain. The guy's unit flooded. He went out and got an attorney and sued them. And they said, well, no, we were working on this. And he said, well, nobody ever told me. So if you're doing something to help an owner with their problem, at least let them know you're doing something, because that's often the case. You know what's going on, but don't assume that the people you're trying to help or deal with know what's going on. So this is important. Communicate what you're doing, maybe newsletters, websites, but give people some idea of the problem, because it's not, you are all in it together. They like to think that somehow you're removed and you're making these decisions that affect them and they don't affect you, and you have to communicate that as well, that we're all going down on the sinking ship unless we do something to prevent that. And it's your part of it, and I'm part of it. Planning ahead, you are supposed to have reserves. That's been the law since 1991. If you don't have adequate reserves, you could have problems. Policies, if you're going to have a policy on collections or almost anything. I had a case once where we had a dispute about insurance and about who should pay for a damage caused by a leaking pipe. And the board, after this issue arose, the board adopted a policy saying this would be the owner's responsibility. We went into the judge, and the judge said, yes, that's very nice, but you adopted it after the problem arose, so it's not going to count. Know what you're doing. Education. Milton mentioned CAI does seminars on a regular basis. You should try to do to at least know what you're doing, get some idea of what you're doing. And it's good that you came today. That's a good sign that you took the time. You could be doing something else to try and find out more of what you're supposed to do as a director. So that is always, I think, worthwhile. And you can, and this is, some owners resent this, but why would an owner have to, why would a board member have to pay for their own training when it's for the betterment of the whole association? So I think that's very worthwhile. And I think if you have the chance, you should get the CAI and other organizations' outlines and try and attend some of their seminars. Do something. This is very important. There are cases saying sitting there and doing nothing when you know something should be done is not going to help you. If you do nothing as a board member, it should be because you investigated everything carefully and decided that nothing was the right thing to do. But it shouldn't just be because you're paralyzed by fear that the owners will attack you for raising a big special assessment or something like that. You are supposed to do something. It's not just going to board meetings and discussing things, it's doing what has to be done. So that's one of the things, and again, as I say, do not cheap it out. If you're a board member, 9 times out of 10, when you're saving money for the association, you're doing that at the expense of your own personal potential liability. Chunks of concrete falling off the building, all that sort of stuff. And then the final thing to remember as a board member is self-governance. This is what I would tell people all the time. Owners would call in when I was a condo specialist to bitch about their boards, and I'd say, I'm really sorry, but except in very limited areas, the Real Estate Commission is not responsible for seeing that your building is run correctly. It is you. So that's why, as a board member, you should be aware of this theory, because that underlies everything that's going on in the law. There have been attempts to get some state official who will come in and slap board members around and make them do the right thing, but that would be an overwhelming task for the state. So I think that's something you have to remember. When owners ask for records, when they criticize what you're doing, that is actually part of their job, and I think Jane will explain that to you now. Thank you.